in these slides here today. At any time, if you have a question, just wave at me. Your questions are all good questions, okay? And you may feel like, oh, I don't want to ask a question in front of my classmates. I guarantee at least probably 5 other people will have that same question, and it will help them as well as you, okay? So please don't be bashful. But I'm going to go through some of this stuff, and, just let me know. Yes, question? Oh, no, they are not. They're showing up locked? Oh. I can probably fix that right now. All right. Let's go ahead and fix that. I'm going to mute this so you guys don't see all the secret things in icon that I have, which apparently I don't know how to run if it's showing up as locked. Okay, I see why this is. Let's move this over here. Can somebody try it again and let me know if it comes up now? It's working? Sweet, okay. It's because I put them in the folder with the super premium study questions, which are still locked. So once we get our participation going, then you can unlock that achievement. We experimented a few years ago with like badges on icon and all that, and it was kind of making it feel like a video game. I don't know, it was kind of fun, but I think we figured out it didn't really make people learn a whole lot better. But I still love the super premium slides. In terms of format of the test, it's going to be extremely similar to what you had for the midterm. And the only difference is you will not have kind of those like large blocks of text with 4 or 5 questions on that case. Like they're just going to be individual questions. It's going to be true, false. It's going to be multiple choice. There's going to be 100 questions. It's going to cover everything from administrative law forward. So if you remember, that was a little inverted. We actually had the admin law class before the midterm, but the content was not on the midterm due to scheduling needs for the midterm exam room. So everything from admin law on forward. Any general questions about the test before I get into it? We've already had one more question than I usually have in these, which is awesome, so thank you. Okay. So thinking back to admin agencies, I hope in light of all the different things that we've covered since then, they begin to make a little bit more sense in what they work and how they do. So remember, one of the interesting things about these agencies is they work or act in the manner of all 3 branches of our government at certain times. So sometimes they have like an investigative function, like going and serving a warrant or making a search of a business, and that looks like our executive branch. Sometimes they're making rules, and then they look like Congress, our legislative branch. Sometimes they have their own administrative law judges, and there might be hearings. And in that regard, they look like our judicial branch. Okay? So they have, within their subject matter area, they have a lot of power. And they use all of these different functions, depending on the agency, to work in that narrowly defined subject area that Congress has assigned them to do. Whether that be the environment, whether that be education, whether that be the treasury and our money supply, whatever it is, there is probably an agency that regulates it. Remember that Congress is the body that sets these up on the federal level. Most of our stuff talked about federal level. There's state level agencies as well, of course. And there it would be our state house and Senate that set these up. But on the federal level, we think about Congress setting these up, and they delegate responsibility to that agency through the enabling statute. Remember that enabling statute is a law that sets out the rules for that agency. It says what they can and cannot do, what their subject matter area is. It sets out their budget. And it also sets out how long that agency will be around. Remember that agencies investigate, and that's part of their regulatory function. So if you are in the business of, well, really about any kind of business that I can think of, you have an agency that is going to be doing some regulating, some oversight. If you're in the financial services business, it might be the SEC. If you're producing nuclear energy, it might be the Department of Energy, okay? If you're running a restaurant, it's going to be the county public health board, as well as maybe the state public health authorities, okay? Whatever, and whatever kind of business you're running, you're gonna, if you have employees, you're gonna be subject to the workplace agencies like the EEOC or the Iowa Civil Rights Commission. So whatever business you're in, there are probably at least one agency that regulates it. And different agencies have different powers, different scopes, but most of them are going to have at least some ability to make an investigation, to come to your place of business and ask to inspect your records, or inspect your kitchen, or your nuclear power plant, or whatever it may be. And some of them would get a warrant to do that, which is where they go in front of a judge and say, we think something potentially illegal is going on. We'd like permission to search. Sometimes they might serve a subpoena, which is a document that requires you to either produce some records or produce some files or objects, or it may compel you to come testify before the agency. And in very highly regulated industries, they might just be able to enter and inspect. So like nuclear power, okay? The downside of a poorly inspected nuclear power plant is so severe that we give them, our regulators, a lot of power just to go have a look around when they need to. So then, in our next chapter, we talked about criminal law and the criminal statutes and all of these different concepts. And I want to hit, actually I want to hit this slide first. Remember that there is a different burden of proof in a civil case versus a criminal case. So the first part of the class, we talked pretty much exclusively about civil cases and civil litigation. And in the second part of the class, we began to talk a little bit more about this different field, this criminal cases. And you know you've got a criminal case if you look at the examples or the hypotheticals I give you on the exam, and you see State versus Smith or United States versus Smith. It's a good chance, if you've got government versus citizen, it's a good chance that's a criminal case. And if you see a hypothetical or a fact pattern where someone is facing jail time and or a monetary fine from the government, that's also an indication that you're on the criminal side. And remember, on the criminal side of things, the government is the named plaintiff. Even though your criminal act may be hurting another human being primarily, we say that crimes hurt society as a whole, and our government has the function of prosecuting those. And when they do, the burden of proof is very high, 99.9-ish%. I think on one exam I had 99.99%, and somebody was like, hey, is this the same thing? Yeah, it's the same thing. All right, let's just say north of 99%. Okay, I wouldn't trick you over a decimal place like that. But we call that beyond a reasonable doubt. Beyond a reasonable doubt. It doesn't mean beyond any doubt, but it means beyond a reasonable doubt, and so we think that is a very, very high percentage. When the government charges a person with a crime, the government has to prove every element of that crime beyond a reasonable doubt. Okay? We have a presumption of innocence for our defendants. So if the government is going to charge you with first-degree murder, they would have to prove all of the elements. That you killed another person intentionally and it was a premeditated killing with malice aforethought, okay? Different states have different requirements. That's kind of the one I remember from law school, but they would have to prove, I counted 5 elements right in there, and they would have to prove each and every one of those to a jury beyond a reasonable doubt, or else you would not be convicted of that crime. And for something to be criminal, in almost every circumstance, you must have a guilty act plus a guilty mind. And the government has to prove both parts of that. The guilty act is relatively easy to determine. Did you kill someone or did you not? Okay. Is there somebody dead? Okay. Is there evidence that you did it? Okay. Now the guilty mind part of it, the intent part, that has to do with circumstantial evidence and what you were doing. Okay. And so for every crime, they have to prove both of those. So we do think about certain defenses that come up here. I think it's relatively rare to have a defense where you're fighting about the guilty act, because there's usually real evidence of that. But the mind part, perhaps the person is not guilty by reason of diminished capacity. They might argue that their mental capacity was such they couldn't appreciate the difference between right and wrong. Okay, that's the monotone standard that we talked about, a very high bar. Or maybe they would say they were involuntarily intoxicated or placed under duress. All of those different defenses that we talked about. Those are getting at trying to show they didn't have the mens rea, the guilty mind. These 4 amendments are definitely worth knowing, both for the exam and for life, because they're really important. They're some of the main things about our government that is so different from a lot of the rest of the world. Each of these 4 amendments have kind of a lot packed in there, except the 8th. The 8th is pretty easy. Cruel and unusual punishment. Yeah, okay. That's sort of one concept, right? Excessive bail and fines. That one really never gets, there's not a lot of cases around that. But 4, 5, and 6 have a lot. So with the 4th Amendment, we think about searches and seizures and the need or requirement for the police to have a warrant to search you. And then we also had a number of cases that showed the exception to the warrant requirement. And I think if I had a named case in the slides, I would have a 1-sentence summary of that case, okay, in your notes. I think that would be useful. So U.S. versus Kilo, infrared camera case. Okay, remember that one where they said it's not okay for the police just to go up and down the street with their fancy infrared camera looking for weed houses. So I would just kind of make yourself a little quick outline of those cases. The 5th Amendment is quite a bit in there, but we talked about double jeopardy and self-incrimination the most. The 6th Amendment, we talked a little bit about the speedy trial. It's important. We talked about the right to trial by a jury and what that meant, important, and the right to counsel. And combining those 5th and 6th Amendment rights, we remember the case of Ernesto Miranda, for whom the Miranda rule is named. And of course, if you've ever watched TV, probably ever, and you saw any kind of crime or police show, you have heard the Miranda rule being read to a criminal defendant. Okay? You have the right to remain silent. Anything you say can and will be held against you. That's the 5th Amendment, right? You don't have to tattle on yourself. If you choose to, we're going to use it against you, and you should know that beforehand. You have the right to an attorney. That's the 6th Amendment, okay? And if you cannot afford an attorney, the court will appoint one for you. also the Sixth Amendment. And the idea is that if somebody is going to talk to the police about a crime that they allegedly committed, you ought to give them, just out of a sense of constitutional fairness, you ought to give them these basic rules. And if you don't, and they confess and you haven't informed them of their rights, that confession might later be thrown out. All right? Then we come forwards out of the criminal law realm, and we go back into civil actions for the remainder of the class. Okay, so our detour into criminal law was interesting, but now we kind of come back into the business side of things, the civil side. And we talked about torts, and essentially these are all the ways in which you might end up harming somebody and having to pay them some money because you harmed them. Comes from the word torture. So when you look at the examples, you can kind of remember that. Somebody gets hurt, somebody slips and falls. It's a tort, right? Tort law is different than criminal law, even though one incident might place you in jeopardy in both systems. So if you do something like you run somebody over, you may have some criminal liability for that. You know, reckless driving, failure to maintain control, failure to yield to a pedestrian, possibly some kind of homicide charge if you kill them. And then you may have civil liability as well, okay? If you run them over and they have medical bills, they or their insurance company is probably going to sue you. And then you might have a negligence case, and that could be money damages. Remember that when we're in civil court, which we are in every chapter but criminal law, that the burden of proof is way lower. So we just talked about criminal law and that kind of 99.9% burden. Remember that in a civil case, it's a preponderance of the evidence. So kind of like more than half, 51%, okay? The burden is lower because what's in play? Money damages. That's all that a court in a civil case can give you is money damages or injunctive relief, like an order to do or stop doing something. You don't get put in jail if somebody sues you in civil court. That's not even an option. That's not even in play. So keep an eye out on the test for red herrings where I might have set up a fact pattern with a civil case and then put in something about jail. Doesn't work that way. A private citizen can't sue another private citizen and have them thrown in jail. Only the government gets to do that. Okay? So I don't attempt to be tricky, but I will check to see if you're looking at which system you're in. Okay? And the plaintiff always has the burden of proof in any case, whether it be civil or criminal. But if you're going to sue somebody else for money damages, it's on you, all right, to take it to that 51% or greater level. The defendant may try to push back as well. So it's on you as the plaintiff. Remember what makes up a tort. These four things. And you got to have them all. If you're going to win a case against somebody, you have to show these four things. You got to show that they had a duty to you, whatever that was, okay? It could be a duty not to punch you in the nose. Sort of a duty that we're all under throughout our day. Or maybe it's a duty to have a safe premise, all right? So in this room, we've got steps. I think most courts would find it's reasonable that we keep those in like good repair and that, they're not like crumbling or peeling or in some kind of way that you could unreasonably hurt yourself, okay? And then you got to show a breach. So in other words, somebody violated their duty to you. Whether they did it intentionally, like they punched you in the nose, or whether they just let something bad happen, like they didn't, clean up the ice in front of their store and somebody slipped. You got to show causation. In other words, you got to convince the judge or the jury the reason I was damaged is because of what this guy did. Okay, it didn't just happen. It wasn't some third party. It was this defendant. And that sounds like a kind of a no-brainer, but you'd be amazed how many people kind of miss that step, right? You've got to show that. And then you got to show that you were damaged. So we don't have hypothetical tort cases. You don't get to sue somebody who's doing something unsafe because you think it might hurt you in the future. You have to show that you were actually damaged, and you have to be able to prove the amount. Negligence is going to be the biggest category of torts, and it's also kind of the catch-all for torts that maybe don't fit other places. It's just sort of the lowest and most expansive category of tort claims. And it just shows that there was some duty, it was breached, it caused damages, doesn't require a certain intent to harm you, doesn't require recklessness, doesn't require anything other than essentially somebody screwed up and left or created an unsafe situation. So we often think about slip and fall, we think about maybe malpractice cases, car accidents, workplace accidents. Essentially we're thinking about kind of whoops, situations, not something intentional, but something happened because somebody was careless. Okay? And in terms of damages that you can ask for from the court, it's going to be limited to what your harm is. Remember that there are some other categories as well. Let's see. Okay. Yeah. So I didn't put slides in on recklessness and intentional, but remember those categories kind of go upwards from there. Recklessness is where it's not quite intentional, but it's somewhere above negligence, really creating a crazy risk, like selling a bag of broken glass as a toy. Okay? Intentional torts, we talked about a whole bunch of different kinds, but that's where your defendant is kind of like affirmatively going around harming people in various ways. It could be a physical harm like assault and battery. It could be a financial harm like fraud. It could be something like defamation, where you're harming somebody's good character in an affirmative, intentional way. We talked about defamation, and I think you might remember the little video of the guy with the spiky hair and the short sleeve dress shirt who came into the lawyer's office. And remember, he wanted to sue somebody who had published a letter to the editor calling him a car thief. What was the problem with that? Well, he actually was convicted of stealing cars. So when we think about defamation, remember, you look for a false statement. It has to be a false statement of fact that harms another person's good reputation. All right? And you might have libel, which is written, or I would say electronic, tweeted, posted, Instagrammed, whatever. Or you could have slander, which is spoken. But in both cases, it requires that you kind of transmit your false statement to a third party. Now, if you're writing it or tweeting it, that's really easy to satisfy. If you're speaking it, you just speak it to a third person other than the person you're talking badly about. Okay? Looking at negligence, remember, duty, breach, causation, and damages. And when you're evaluating a situation, think about that foreseeability issue. Remember that Paul's graph case where the railroad employee was helping the guy on a train, the jolly little fool, and the fool had a briefcase full of explosives, and those fell because the employee of the railroad pushed him up onto the train, and the briefcase fell, and it exploded, and the shockwave went down the platform, and it hit a scale, and that fell on Mrs. Paul's graph. And she sued the railway, not the fool, not the employee, but she sued the railway who owned that station and that train. And the court said, it's too much between this and this, okay? They said it was not foreseeable to the railway that their employee helping a man up onto the train would have explosives in a briefcase. Who does that, right? That would go down here and hit their scale and fall on Miss Paul's graph. They said, it's too much. It's just too far apart. All right, so when you're looking at a fact pattern, think about that case. Is this too far apart? Is it foreseeable? Other things that might come in here, actually you can forget negligence per se. I always mean to delete that from this slide and I forget to. But res ipsa loquitur, which we'll also talk about in the product liability setting, is a thing speaks for itself. So when a doctor operates on a patient and then a month later it turns out the patient has like a piece of surgical or some surgical tools still in their body, okay, who did that? Well, we don't have video of the operation. We don't have any witnesses because this guy was under anesthetic and the doctor's not talking. But seriously, how else could it have gotten in there? That's res ipsa loquitur. The thing speaks for itself. So if you see that, just kind of think about, seriously, how else could it have got there? Strict liability. I don't know if I have my favorite. Yeah, there's my favorite slide on strict liability with the guy that uses explosives and the swimming white tiger. And if you've never seen this white tiger, he's got some YouTubes and stuff. He swims around, eats giant hunks of meat. He's really cool. But if you keep him at your house and you have people over and he bites them, you're going to be strictly liable. It doesn't matter that you've taken him to tiger good citizenship classes, and it doesn't matter that you've trained him not to bite visitors. And it doesn't matter that you had a big sign on the swimming pool that said, danger, white tiger likes meat, okay? None of those things are going to help you when you're doing something ultra hazardous, like keeping a tiger or using dynamite, okay? Those are strict liability settings. If you do it, and if it harms someone, it doesn't matter how careful you were, you still have to pay for the damages. When can a person or a business defend against a negligence case successfully? Well, they have a lot of different options. And one of the defenses is, this was partly your fault, okay? So I think I told you the other day I was driving, and I was down here on like, I don't know if it's Madison Street, and I was going by the main library, and I'd stopped at the stop sign, and I was going slowly, and a student walked out into the middle of the street, not near a crosswalk, looking the other way on her phone with headphones in. And I kind of came to a quick stop, and she looked at me, gave me kind of an ugly look, and then kept going. Okay, now I'm not allowed to run somebody over, even if they're doing things like, jaywalking, going into the street in the middle of the street, not paying attention, blocking out their senses by looking away and having music on. But if I had hit her and she sued me, I think one of the defenses I would have raised in court was something like this comparative negligence. And I would ask for an instruction to the jury saying, yeah, my truck hit her and that was, caused some damages, but she was doing all these other things. I'm asking you to reduce the amount of damages by what percentage you think she's responsible. Okay? So Iowa follows this kind of 50% rule. And it says if the plaintiff is more than 50% responsible for the damages, then they don't get anything. All right? Other states might allow it to go up to like a 1% defendant, 99% plaintiff. But Iowa kind of has this middle ground that says if plaintiff's more than half at fault, they don't get to collect anything. Other defenses, assumption of risk is one of the big ones. If you go bungee jumping, if you go parasailing, skydiving, you go running with the bulls, something like that, and you get hurt and you try to sue the person or company who allowed you to have that experience, you probably won't get very far because the court is going to find that you assume the risk of that activity. As long as you did it knowingly, like you knew what you're getting into, or you should have known, okay? Also, there might, in certain situations, be an actual waiver that you signed or that you accepted. If you go to a baseball game, the back of the ticket is going to say, there's a chance you might get hit by a baseball. There's a chance you might get hit by a broken bat, okay? By buying this ticket and attending the game, you agree to waive a cause of action against the team or the stadium for that. Or you might sign something. If you've ever done something like parasailing through a professional company, you're probably going to sign a whole bunch of waivers saying, yeah, I understand this is dangerous. Yeah, I still want to do it anyways. Yes, I agree not to sue you. So those are some of the defenses. Remember from product liability that these claims are primarily tort claims, okay? It's just another area of tort law for the most part. And it has to do with when people are injured or damaged by a product, who can they sue and for what? And remember that this was almost like a little history lesson, this chapter. And it started all the way back with the old school rule, which is you're hurt by a product, who can you sue? Nobody. You're screwed, okay? Caveat emptor, buyer beware. So that's how it started. Then we had some cases over time. Remember those cases with the wooden wheel and the triple shatterproof glass windshield that wasn't? And those, and then all the way up to Miss Escola with the Coca-Cola bottle. And over time, the courts became a little more friendly toward people and a little less friendly toward the companies. And they started saying, yeah, people are getting hurt by these products, and it's not really fair that they don't have any way to claim damages. So we're going to allow them in some ways to make claims. And kind of all the way up to Ms. Escola, if you remember, she was holding the Coca-Cola bottle that exploded when she was going to serve it to a customer. And that was one of the first cases where the court used this strict liability in product cases, where they said, you know who's responsible for that blowing up bottle? Coca-Cola is, because they're the only one that could be. They're the only one who had control over it. Now, even if they claim their production line was working well and they took the precautions, who else are you going to sue, right? How else could you make a claim? And so that's kind of mostly where we are today, that sort of strict liability. And, you know, we talked about some specific ways that can be claimed. And then the warranty stuff. If a business makes promises about a product being suitable for certain things or being of a certain quality, and you know they intend to get people to buy the product based on their claims, they have to live up to it. And if they don't live up to it and people are injured, then you may be able to sue them for damages. Okay? Then we got into contracts, which of course encompassed a whole bunch of different concepts. But remember, when you're looking at a contract, remember either these words or these pictures. You've got to have an agreement, some kind of lawful consideration. The people have to have capacity to enter into the contract, and the subject matter must be legal. Remember, with acceptance, you got to do or say something to accept a contract. There's no such situation as calling somebody and leaving them a voicemail saying, if you do not contradict me by tomorrow, then we have a contract for me to buy your car for $1. It doesn't work that way. They got to do something, okay? And the common law rule is that an offer and an acceptance have to be on the same terms. Now, when we got to the next chapter, the UCC, you remember that requirement is relaxed a little bit when businesses are making contracts or buying goods from each other. But at common law, an offer and acceptance have to be exact. Consideration can be anything that somebody would want to bargain for. So I had somebody ask me today, what's up with that Hamer versus Sidway case? That was the uncle who paid $5,000 to his nephew in consideration of the nephew not drinking, smoking, gambling, or playing billiards during college. And the question before the court was, is that consideration for the uncle? Like, he's not actually getting anything tangible. He's just getting the knowledge that his nephew is living a clean life. And the court said, that's weird, but we're going to allow it because it had value for him. So remember, the court doesn't go in and look at, like, how good of a deal is this? They just look at, is this something that someone would possibly want to bargain for? Remember capacity? Got to be 18 to enter into a binding contract. Got to be mostly sober. And got to be mostly sane. Remember this little grid of where a contract might be. All right? It kind of reversed my colors. That's kind of weird. So the red one up there is actually the valid contract. Voidable contract is where there's a problem that might come up later due to something about the parties. And those bottom two, you haven't got a contract at all. Remember the cases about mistake? So the cow case, both these guys thought they were making a transaction over a cow that could not have babies. Actually, no cow can have babies. A cow that cannot have calves. That would be really weird if a cow had human babies. That's totally beyond the scope of this class. But they both thought this cow was not able to reproduce. Let's just say that, okay? They both thought the cow was not able to reproduce. And then it turns out it was. All right, so the court unwound the transaction and said, you got an unjust benefit because you have this cow that can make more cows, and you didn't pay enough for it, okay? And it wasn't the price that triggered it. It was the fact that they both negotiated based on a mutual mistake. Remember our old friend, the Statute of Frauds, an oddly named provision in state laws that tells you when a contract has to be in writing. There are typically 6 things, but the first 3 that I've bolded and blown up here are the big ones. You see a sale of goods over $500, probably got to put that in writing. Any interest in land, real estate, probably got to put that in writing. And if it takes longer than a year to perform, got to put that in writing. Then we came forwards to business organizations. And what I think you might want to do for these is just have a couple bullets, kind of like I do on this slide and the next slide, with kind of a pro and con for each one, maybe. Kind of know like which ones are better for taxes, which ones not as good. A little bit about, I may throw you a hypothetical on the exam and say, here's this kind of business. Would it be good as a sole proprietorship? Would it be good as a corporation? Remember, there's different ranges of asset protection that come in with these things, and there's different levels of how complicated is it to set up. So I just kind of look through there and know those entity types. And then remember a little bit about this corporate governance, how the shareholders elect the directors hire the executives, and then the executives hire the employees, and that's how a company runs. The directors are kind of your long-range strategic thinkers. The executives are doing the day-to-day top management. And the shareholders, maybe they're going to vote once a year, okay? They're not involved with the day-to-day. Then we come forwards to employment stuff. Remember the 2 different types of workers that we talked about. Independent contractors versus employees. And that for your employees, you've got to pay taxes and benefits. And you bear more responsibility for what your employees do. Okay? So that makes independent contractors a little more attractive to some businesses. But remember that you don't get to exercise as much control over them. And if you treat your independent contractors like employees, a court might decide they are employees. And you might be liable for taxes and for things that they do in the workplace. We talked about some of the laws that set the table for employment law that we currently have, particularly anti-discrimination laws. And this all came out of most of it came out of the 60s. And the Civil Rights Act was one of the first and still remains one of the most important pieces of federal law on this, okay? And remember that these laws set up kind of a jurisdictional aspect, saying that if you've got 15 or more employees, you've got to comply with this anti-discrimination stuff. And if you're involved in interstate commerce, we're going to have jurisdiction over your business as far as this anti-discrimination stuff goes. And we're creating this agency, the Equal Employment Opportunity Commission, to administer these laws, to make investigations, to make rulings, all right, to enforce these kind of things. And so even though you may be a private business, you still have to follow the anti-discrimination laws, whether it's in employing people or serving people. You know, we had cases like Katzenbach versus McClung, the Ollie's Barbecue case, which said you can't discriminate against customers based on their race. Okay? So this all ties in with the Civil Rights Act. Remember that states have their own employment law as well. And we really just talked about Iowa, because employment laws vary quite a bit. But in Iowa, we've got our Civil Rights Commission, that's like the EEOC, and Iowa law covers even smaller businesses, starting with 4 employees. And then you can even have a city level. So we have an Iowa City Human Rights Commission, and they have rules too. If you haven't viewed the video yet, I'm going to be sort of speaking ahead of it, but I think that's okay, because then you'll hear it twice. But in that section, I talk about the Americans with Disabilities Act, and I talk about the duty of reasonable accommodation. So the idea behind the Americans with Disabilities Act is that if you're a qualified individual working in a job and you have some kind of disability, and an accommodation for that can be made without undue hardship, and it will allow you to do your job, then the employer has to do that under the law. So it could be something like a wheelchair ramp to get to your desk, or it could be a magnifying device if you're visually impaired, or whatever. Okay, but you'll see in the video I go over this in quite a bit of detail. I think one of the key takeaways from that is with an accommodation, it is not to give the person a unfair advantage or a head start, as people sometimes criticize. The idea is to put everyone on a level playing field. Sexual harassment is a form of workplace discrimination. And again, I discussed this at some length in the video, which I have shared with you. But the reason it's classed in employment discrimination is because it's gender motivated, okay? And various cases have come up to the Supreme Court, and they've held that these rules apply to men harassing women, men harassing men, and women harassing women, women harassing men, any possible permutation of this. If the harassment is motivated by gender, then it falls under sexual harassment. And we tend to think about these cases in 2 different ways. There's a quid pro quo, which is when someone demands or asks for sexual favors, and they say they're going to give you an employment benefit because of it, like a promotion or a bonus or something. Or the hostile workplace, which is where people are essentially doing things that are illegal harassment. Could be dirty pictures, unnecessary touching, speech, things like that. Okay? And there's a couple cases in here I think that are worth just, again, kind of knowing, like a one-sentence thing. This Harris versus Forklift Systems is the case that puts out the test for whether a place is a hostile environment in a workplace. And they said, okay, well, we look at the frequency of the conduct, the severity. Is it physically threatening and humiliating? If yes, then it's more likely to be a hostile workplace. And does it unreasonably interfere with work performance? Then these two slides you'll also see in the video, but I do want to take a minute here just to explain these in a little bit of detail. These are the two pathways that you can take in bringing a claim against an employer for discrimination. There's disparate treatment and disparate impact, okay? And they come up in different settings. Disparate treatment or intentional discrimination is when you believe that an employer has specifically and intentionally and somewhat openly discriminated against you because of a protected class. Okay? Like you think you applied for a job and you think you didn't get it because of your color or your gender or your religion or something like that. And you're saying, hey, this employer actively decided not to give me the job or not to promote me, or they decided to fire me because of this demographic factor that's protected under the Civil Rights Act, okay? So in that case, the plaintiff has to make the first showing. This is long before trial. But the plaintiff has to, in their petition, show or sketch out a case that this is based on a discriminatory reason, okay? So maybe you put in your petition, I applied for this. I was a woman. They didn't hire me. I think it was because of that. They continued to accept applications, and eventually they hired only men for this job, all right? Then the burden shifts, okay? Once you've made that claim, the burden shifts to the employer. And then they've got to come up with a decent reason, a legitimate and non-discriminatory reason for the action. So they're probably going to come back and say, well, this person was not qualified for the job, or this person wasn't a good fit, or whatever, okay? So it doesn't have to be a great reason, but some kind of legitimate reason. Then the burden shifts back to you. And then you have to say that, no, I was qualified, I was a good fit, it was discrimination that prevented me from getting this job. And if you can get through all of that process, that's when the matter then could get to a trial, okay? That's for a claim of intentional discrimination. There's this disparate impact, and I think in many ways this is probably the more common route to filing a case, because very few companies are going to be stupid enough to say something like, job opening for 5 people, would prefer women not apply, okay? Like, that's kind of a really dumb thing. I'm not saying there aren't employers that still do that, but that's really stupid, okay? Employers get a little sneakier sometimes. So in New York City, there is something like 27,000 firefighters. And of those, there are like 3 women firefighters, okay? It's a huge disconnect, right? And firefighting agencies, I guess, or departments of city government are one of the places that have been sued a lot for discrimination under a disparate impact framework, okay? Because a lot of firefighting departments don't want women employees for whatever reason, okay? And so they get a little sneaky. They put in requirements that seem neutral, but have the effect of discriminating against women. Like, all applicants must be 6'2". Okay, I'm nowhere near 6'2", but a lot of men are. Women, it's much less likely you're going to be that tall. Or they might have a minimum weight requirement of 180 pounds, or maybe you have to be able to lift 100 pounds over your head, okay? So we know that those kind of tests would favor men in the general population. And so if you're a woman and you want to be a firefighter and they say, sorry, you're not 6'2", you can't lift 100 pounds over your head, can't hire you, okay? And then you start to look statistically at it and say, well, under these rules, they almost never hire women. This is discrimination, even though they're saying it's neutral, okay? So in that case, you make your claim and say, look, 100 women and 100 men applied for this job. They hired 100 men, they hired 0 women. It has to do with this policy of you've got to be a certain height and you've got to lift a certain amount of weight, okay? There's an adverse impact. Even if they claim it's not intentional, the impact is such. Then it shifts over to the employer. And then they've got to say the necessity of those tests or traits or measures, okay? So they would say like, well, if you're not at least 6'2", you can't look in a window to see of a burning house to see if there's somebody in there. Or you have to be able to lift 100 pounds because our ladders are really heavy, okay? And this is where you get into, hopefully, some scientific evidence on both sides. And you're going to argue, no, that's a pretext. You don't need to be 6'2" to look into a house. You could just climb up on the truck and look in. Or, you know, nobody carries the ladders by hand anymore. We have a machine that, you know, on the truck that does that, or whatever. Okay? So if you can kind of show that it's a pretext, then you can get into court and get into a determination of, is this discriminatory or not? So I guess what I'm saying to you is that in an employment discrimination case, there's this extra process before you can even get into court as a plaintiff. And it is kind of a difficult one, okay? But that's what we have. You guys viewed the video lecture on workplace respect and workplace bullying. Hopefully you found it instructive. I think it's a topic that continues to be, unfortunately, very important these days, but a couple points with it. So one of the main points, how do bullies choose their target in the workplace? There is a misconception that they choose people who are weak. That's kind of what a schoolyard bully might do. But in fact, bullies in the workplace often choose a person who's up and coming, who threatens them, threatens their insecurities or their position, okay? How do we know when something is, a pattern of conduct is bullying and not just a rude person? Well, remember, we look at the intensity and the duration of it, okay? Is this really harmful conduct that is happening over and over? Is it intended to destroy somebody's career? Then it falls into the bullying thing. Criticizing somebody's work performance legitimately is not bullying. That's part of the job. But it's when you're going after the person personally. And remember that this leads to many, many costs for a company. Turnover. People leave a company when they experience this or when they witness this happening to others. They might take their clients with them, okay? So you lose that. Absenteeism. People will call in sick to avoid this crap. Or they might appear in person because they feel they have to, but they're so upset they're not productive at work. Sometimes companies are sued for this. They might enter into settlements. And there's also workers' comp and insurance costs for people who suffer from this. Those are the slides I had. If you have questions, feel free to come up. I'll hang out for a minute. Otherwise, we'll see you guys at the exam. Thank you.